Right, let's get started. Please take your seats. Welcome, everyone. Welcome, and thank you for coming to our 6th annual Codex FutureLaw conference. It's wonderful to have you all here with us today. My name is Roland Vogel. I'm Executive Director of Codex. And so it's my privilege to welcome you here. We have an exciting conference ahead of us. We have a wonderful lineup of experts from around the world, and also a really interesting community of people in the audience. So it's really amazing and fun to see so many friends and so many new faces, and I think we have a really exciting day ahead of us. I think we're at a point in time where the robo-lawyer has become a household concept, and I think lawyers are no longer asking whether technology will have an impact on how the industry works, but how to best get on the bandwagon. So certainly AI, big data analytics, algorithmic decision making, the blockchain have created a host of new opportunities for this industry, but also many new challenges. And we have some of the world's leading experts here with us today to help us make sense of it all. Our conference will start with a keynote by the president of the ABA, Hilary Bass. Her talk is titled Partners in Law, Breaking Down Silos Between Law, Technology, and Innovation. And then we'll have our first, after a short break, we'll have our first panel discussion on fairness, accountability, and transparency in algorithmic decision making. That will be at 10 o'clock. That will be followed by our first legal innovation lightning round. We actually had, last year, we had a legal innovation lightning round, and that format was very well received, and so we decided to have two lightning rounds at this conference. After that, we'll go into our lunch break at 10 past 12, and we'll pick it up again at 1:20 to get an update from Peter Gunst about trends in our legal innovation ecosystem based on data from our Codex Tech Index database. Then at 1:40, we'll have our first afternoon panel on using AI to push legal research, and that will be followed by a panel on RegTech, asking the question whether we are in the golden age of RegTech. And after that, we have a session on blockchain beyond ICOs, which will be followed by our second legal innovation lightning round at 4 o'clock. And then our very own Professor Rodi will be closing the conference with a closing keynote on access to justice and legal services for routine needs and new technologies meet bar regulators. And that will take us into our evening reception. Legal innovation has really become a global topic. There's exciting innovation happening all around the world. We are fortunate to have with us people from around the world, including a group of 15 people who flew all the way up from Brazil to join us for this conference, but also people who come from India, from Europe, from all corners of the world. And so we really welcome you all here and really appreciate you having taken on this long trip to be with us here today. This conference is all about engaging in the deeper issues presented by emerging technologies and how they impact the law. And we hope that this conference is not only an opportunity to bring the community together, but also an opportunity to share experiences and collaborate on new projects and plan for the future. So I would like to say a few thank yous. First, of course, to our affiliate and conference partner, Thomson Reuters, for their direct, generous support of this conference. I would also like to thank all our other affiliates of the program in Law, Science, and Technology for their generous support. Our conference partner, the Stanford Center for the Legal Profession, under the leadership of Professor Rodi and Lucy Rika, for their support of this conference. And, of course, to the Stanford Program Group under Trish Gertrich for their tireless work and making sure that everything works, and then, of course, also to Codex Residential Fellow Susan Salkind, who was working with me in putting this conference together. So it's now my pleasure to introduce you all to our keynote speaker, Hilary Bass. Hilary is the president of the American Bar Association and a co-president of Greenberg Traurig. She's a prolific trial attorney with a highly successful career in litigation. She's one of the most recognized women attorneys in the United States. She serves on Greenberg Traurig's executive committee and previously served an 8-year term as national chair of its 600-member litigation department. She's also founder and former chair of Greenberg Traurig's Women's Initiative. Her work is recognized in the industry as she's consistently ranked as one of the country's top lawyers. In recognition of her high-profile successes as a trial lawyer, she was inducted into the American College of Trial Lawyers. And beyond, I mean, there's so many things I could say, but she's also been very dedicated to the mission of the American Bar Association for more than 30 years, beginning as a young lawyer and now serving a 1-year term as the ABA's president. Hilary also serves as the vice chair of the University of Miami's Board of Trustees. So please welcome with me Hilary Bass as our keynote speaker. I can't think of anyone better to kick us off here today. So thank you, Hilary. Yeah, so if I don't fall down the stairs, we can get started.
Take your time. Yes. Well, good morning, and thank you, Roland, for the introduction and for the invitation to talk with you briefly this morning about what the legal profession and the American Bar Association is trying to do insofar as accepting and adopting legal technology to make us more efficient and to help to bridge the justice gap. First, I'd like to praise Codex and its teams that are currently using technology for the specific purpose of trying to break down boundaries in providing traditional legal services. Among the Codex projects that are specifically using technology to broaden access to justice include computational law, which aims to automate legal analysis and bring legal understanding and legal tools to everyone in society. The Stanford Veteran Benefits Project, which is developing a TurboTax-like software application that can determine a veteran's eligibility for benefits and then help provide the resources they need to access those benefits. The Blockchain Group, which is a forum to convene experts who seek, among other goals, to use technology to expand access to justice. These projects are ambitious, but they're also imaginative, and they're disruptive. And they would not advance without Codex's support and teams of visionaries and world-class experts helping them to accomplish their goals across multiple disciplines. Leadership guru Ken Blanchard likes to say that none of us are as smart as all of us. So Codex gets that. And the American Bar Association gets that. We also get that partnerships are not easy, and that oftentimes they must break traditional models. And of course, we know that partnerships cannot work within just one discipline. Most importantly, the ABA gets what probably we get better than anyone else, and that is lawyers are a tough audience. For the most part, we're accustomed to looking in the rearview mirror. That's what we were trained to do when we became lawyers. And as much as we may intellectually understand that the law is transforming and that we must get on the bandwagon, for many of us, it's a very difficult transition to make. So we understand that the ABA has much to learn in this space, much to learn from people like yourselves. And that's why we're here. And that's why we ask you to be involved with us. Lawyers really can be great collaborators. But as legal technology entrepreneur Monica Zent put it, how lawyers collaborate is stuck in the past. At the ABA, we are trying very hard to get unstuck. We are leading and joining constituencies across disciplines to harness technology with the mission of improving our profession, bridging the justice gap, and serving our clients. So many of you know that about 4 years ago, one of my predecessors created a blue ribbon panel to recommend new paths in the legal profession. It was called the Commission on the Future of Legal Services. And in 2016, after 2 years of work, the Commission put together a lengthy report with fresh thinking on creating a more just and open legal system. One of the recommendations was to create an ABA Center for Innovation to encourage, support, and drive innovation within the legal system, to pull together the expertise of various players, law firms, local and state bars, law schools, private businesses, the National Center for State Courts, the Legal Services Corporation, the Conference of Chief Justices, and others. Why? Because the Commission recognized that no one constituency could successfully achieve what the goals were. And we recognized that other industries and professions that had not responded quickly enough to advances in technology faced real disruption. So the Commission concluded that industries as diverse as consulting, medicine, and personal finance had made investments in research and development laboratories to create new service offerings and substantially improve client relationships. So we urge the legal profession to do the same and propose the creation of the Center for Innovation. So the Center for Innovation opened in 2016. Its mission to encourage collaborative thinking and innovations to improve the affordability, effectiveness, and accessibility of legal services. It aims to be creative, to be daring, and to be a powerful force for change. Now, I know you're all listening to that and thinking of lawyers and saying, which of these does not fit? But one of the first initiatives of the center was to create a fellowship program. So these fellowships allow lawyers to spend a year away from their practices to work on projects to better the legal profession and the justice system. So last July, we announced the first group of 8 Center for Innovation fellows. 5 were young lawyers who committed to take a full year as fellows, and the other 3 were mid-career lawyers who each committed to take 3 to 4 months to work with the innovation centers. So among the fellows' projects for this year include the following: a blockchain service tool to help low-income people in court gain more control over the trial process, a privacy checkup tool, an evidentiary toolkit for civil attorneys in partnership with the National Network to End Domestic Violence. One fellow who's here with us today, Amanda Brown, I see her over there, is working at Microsoft headquarters on a project in partnership with the Legal Services Corporation and Pro Bono Net. This is an innovative legal nonprofit that uses technology to reach the disadvantaged. So Amanda is working with others to develop online portals for Hawaii and Alaska, specifically for people who would otherwise use the benefits of legal aid. It will be unveiled in a few months, and the point of these portals is to provide access to user-centered technology that will help link people with civil legal needs with the services that are available, both through legal aid, through the court system, bars, and community organizations. And I know Amanda will be around later today if any of you have specific questions. But this is just the beginning, these fellow projects. The ABA is already engaged in a number of innovative projects and partnerships to improve the legal system and the profession. So among our projects that are in partnership with technologists, a hate crime app. This is an app that was developed in partnership with Cisco, Curo Legal, Stanford University, and Suffolk University Law School. It helps people with a free downloadable app determine if they have been a victim of a hate crime, what the law is in their state, and what the specific resources are in their location to be available to assist them. More than 1,300 people have used this app in just the past few months since it was launched. We are partnering with law enforcement. So in New Orleans, the ABA is working with the city police department to test a model app that translates Miranda rights into Spanish. potentially this will be a free downloadable app that will be available to police officers throughout the country. And if it works in Spanish, our next goal is to translate it into French and Vietnamese, as well as more languages will follow. And again, this is something that everybody is in support of. The district attorneys, the police officers, the defense attorneys, because no one wants a defendant brought all the way through the system to have a charge thrown out because they did not understand their Miranda rights because they did not speak English. So why shouldn't every police officer across the country have an app on their phone that once they determine the person they're about to arrest only speaks Vietnamese, that they can type in that language and have a video of someone speaking in their native language giving them Miranda rights. So this is a project that we're doing in partnership with the Illinois Institute of Technology, Institute of Design, the National Center for State Courts, Chicago-Kent Law School, Tulane University School of Law, and Harvard's Access to Justice Lab. We are also working in partnership with academics. We created a flood-proof app. Now, this was in partnership with Stanford University Legal Design Lab, Louisiana State University, Southeast Louisiana Legal Services, and the ABA Center for Innovation. So the purpose of this legal app, excuse me, is to help flood victims track down the information they need to prove title to their property so they can make an appropriate FEMA claim or insurance claim. This was launched in January of 2017 in Louisiana, and so far has helped more than 160 Louisiana families who otherwise would have lost whatever documentation they had to the flood, so they're able to find the information they need to get appropriate assistance. This app is now being transformed into applicable use in Texas, and it's being considered for development in the Virgin Islands, as well as Florida and Puerto Rico. We are also partnering with government agencies. We have a legal technology social philanthropy project. This is a partnership between the ABA and Legal Services Corporation. So the two goals here, one is to provide cutting-edge technology to legal aid providers so they can serve more clients. But the other half of the partnership is to provide legal tech companies an audience to demonstrate the efficacy of their proposed product, to allow them to have a demonstration opportunity and to increase the efficiency by which their product will eventually help legal service providers. So the ABA and the LSC will facilitate the donation or low-cost provision of this legal technology to LSC offices throughout the country. The Center for Innovation will recruit legal tech companies. LSC will identify which technologies have the greatest applicability to their market, which are best suited to assist in the provision of legal aid services, and which LSC grantees are best positioned to utilize the technology. Legal tech companies are able to give back to their communities and receive feedback on their product from lawyers and providers who are trying to serve more clients with fewer resources. Companies can gain exposure of their products to potential customers, including private practice lawyers who volunteer at legal aid offices. This project will launch April 30th, and our first legal tech partners are MetaUre and Ross Intelligence. So if any of you are interested in volunteering for this effort, you can go online after April 30th and considering partnering with LSC and the ABA to get your legal tech product out there, tested, to be able to come back to you with specific ideas about how to improve your product, and then have the seal of approval about its efficacy being used by legal service providers throughout the country. We're also partnering with local and state bars. So this past year, in a partnership between the ABA and nearly every one of the 50 state bars, is known as ABA Free Legal Answers. This is a free online service that allows people who have legal questions to type into their computer what their legal question is and have a lawyer sitting in their office somewhere on a coffee break without creating an attorney-client relationship to simply type in the answer to the legal question. Low-income clients from nearly every state in the country will be now able to pose specific legal questions to lawyers and receive simple answers online. More than 4,000 attorneys have already registered to provide this pro bono service. About 18,000 client questions have been posted to the site since the launch 18 months ago. And what's particularly useful about this capability is that when the floods hit Houston, the Texas Supreme Court issued an order that said for a 6-month window, lawyers not barred in Texas could provide pro bono legal services to flood victims, even though they were not barred in Texas. Well, ABA Legal Answers at that point becomes critically important, because on an ABA disaster legal site, we provide attorneys basic information about how to answer the basic questions that we all know disaster victims have. How do I file a FEMA claim? What kind of documentation do I need to make a claim with my insurance carrier? And here, totally online, available to the lawyers, are the information they need to answer basic questions. And then here you have hundreds of thousands of disaster victims in Texas, all with immediate questions that they want answered, and the ability for any lawyer across the United States to be able to go online and in 5 or 10 minutes really provide meaningful legal information to people in need. Now, we are also working to partner with courts. And though it is not a reality, I am hopeful that the ABA will be able to work with the courts to develop specific ODR for small claims. As many of you know, our current small claim system is such that if a low-income person has a $1,000 claim because of a repair that was not appropriately handled, their option to go after this very significant amount of money for them is to file a claim in small claims court, wait 6 weeks, take a day off work, get on a bus, go cross town to some courthouse they've never seen before, wait for 3 hours, get there 3 minutes in front of a judge for the judge to say, go in the other room and try and resolve this. When they come back and say, I'm sorry, I can't resolve it, they're told, well, come back in 6 weeks, take another day off work, get on another crosstown bus, and spend another day sitting in my room waiting to get my attention for 3 minutes. This does not make sense for anyone involved. Why can't we do this entire system online? And this is where you get into the challenges of lawyers being stuck. Because when I first came in as ABA president and I suggested that this was something we could easily help develop, the response I got from many of the people I spoke to is, oh, this will take 3 years to develop and $2 million. And my response was, well, wait a second. Everybody has a smartphone. Why can't we create a system where people simply dictate their claim to a dedicated email address that goes to a judge? The judge can deal with seeking the response, and the whole thing can be handled by Skype. Now, obviously, there are lots of challenges, due process issues about service, lots of challenges that have to be addressed, and issues that have to be resolved. But the reality is that 80% of the people in our country do not have access to basic legal services. A significant percentage of them don't realize that the personal problem they're dealing with, maybe they're being inundated with the bill collector's phone calls at work, or maybe they're being threatened with eviction or foreclosure. Believe it or not, many people do not understand that these problems that they're dealing with every day are legal in nature, and that a lawyer could assist them in solving them. But even those who recognize, I need a lawyer, I need help, this problem has a legal solution, do not believe that they have the capacity to hire a lawyer. So it's people like those of you in this room that need to figure out ways that we can solve complicated problems with relatively simple technological solutions. ODR is certainly an example of that. We know that in British Columbia, they have a small but very successful ODR program that was started last June. It has handled more than 14,000 cases in its first 7 months, and a number of U.S. jurisdictions are considering this, but none have implemented it yet. I suggest to you that if any of you want to come up with a solution on this one, there will be lots of takers, because this is a problem that is easily capable of solution, but it's going to take the imagination of people like yourselves to come up with the best way to resolve it. Now, obviously, the ABA is also in partnership to provide tech resources to our lawyers. So one of the things we do is we partner with legal technology experts to bring the most up-to-date offerings to our lawyer members. So annually, we have an annual ABA Legal Tech Show, Expo, the most comprehensive lawyer-focused legal technology event of the year. It's held annually in Chicago, but it provides practical, hands-on advice for lawyers who are looking for technology to enhance their practice. This past spring, we had more than 2,000 people attend and more than 120 vendors who were there. Tech Show is a partnership of legal experts, tech companies, and local bar leaders, all trying to do the same thing, which is help the legal profession figure out how best to incorporate legal technology into their practices. We also have a Legal Technology Resource Center. This is within the ABA Law Practice Division, but it provides legal technology resources to the ABA members through various outlets, including a blog, Legal Tech Today, print and online publications, Legal Technology Buyer's Guide, and others, free webinars, and an extensive website. So this is the type of thing, it's our ability to get out to our membership information about the most cutting-edge legal technology that's available. We have a 3-person governing board that includes a lawyer, a legal technology expert based in St. Louis, Dennis Kennedy, and a national litigator based in Louisville, Steve Embray of Frost, Brown & Todd, and the director of the Law Practice Management Program at the State Bar of Georgia. So that can be found on legaltechnology.org, and it's our effort to really spotlight the most advanced legal technology for our members. We also have a very well-recognized ABA cybersecurity legal task force, and this is a group of really the cutting-edge experts in this field from across the country. We just published our 2nd edition of the ABA Cybersecurity Handbook. It is a bestseller. It's a resource for law firms, lawyers, and business professionals, and it really reflects all of the current issues in cybersecurity. Another project that we're currently working on is to update our task-based billing codes. Now, many of you may realize that most people, most attorneys in this country, bill their time through ABA task-based billing codes that were developed, let's just say, more than 40 years ago. They've been very effective for a very long time. But one thing that I was keenly aware of is they do not work with e-billing, do not work particularly well with e-billing, with fixed fee arrangements, or with many of the types of AFAs that our clients are now demanding. So we are modifying those codes. We will create a new system, a budgeting and billing system, by August of this year that will give clients and lawyers meaningful cost information on legal services. It will facilitate the ability to bill all through e-billing. It will facilitate the ability of clients to slice and dice the information in meaningful ways. And it will also allow us to meet the requirements of billing by phase, fixed fee approaches, etc. So look for more about that. We began last summer, and we included representatives of various law firms, private legal service companies. There will be 10 new code sets for a variety of law functions, including litigation, criminal law, workman's comp, bankruptcy, etc. And so our goal is to have them unveiled by our annual meeting this year in Chicago. So in closing, let me suggest what you all know. It's not easy to get lawyers unstuck. If it were, more of the legal profession would already be more receptive to technological solutions and to adapting to the transformational change that is sweeping through our profession. But Codex is unstuck. And as the ABA travels this path, we and the rest of the legal profession are really looking to you, watching where you go, what you do, with much anticipation. So For our benefit, please continue to be bold, be adventurous, be creative. The future is now, and the collaborators of Codex are writing its playbook. We look forward to working with you. We really do need your help, but we believe with the resources in this room, the legal profession can get unstuck, and we look forward to that day. Thank you so much, and I'm available for questions if anyone has any. Yes?
Great stuff. Thanks so much.
Would you mind coming to the mic? The videographer asked if we would make sure you do that.
Hi, thanks. John Broder with Vortex Legal out of Florida, so good to see you here. But my question is there's a lot of great stuff that you guys are doing. The one thing I didn't hear is what is the ABA doing regarding an ethics opinion or some sort of guidance on the technology and the unauthorized practice of law, that gray area where there's a lot of resistance in that space. Are we going to see an ethics opinion, some sort of guidelines as to what is and what is not unauthorized practice of law, and what is, where does alternative legal service providers fit in?
Well, you've probably hit on the single toughest issue for the legal practice. There's no question. I mean, we have looked into trying to create a definition of what the legal practice is, because we all recognize that has changed. One of my other initiatives is a focus on the future of legal education, because the idea that simply knowing the law makes you a lawyer or makes you a practicing lawyer. Obviously, I'm waiting to see the first unauthorized legal practice claim against Siri or Google. So we understand that legal practice has got to be something more than simply reciting what the law is. The challenge is that we have yet to be able to figure out how to describe what that means, and we've worked on it. This past year, the House of Delegates, which is like our Congress, 600 representatives of local state bars from all over the country, came up with a list of criteria that legal regulators should consider in thinking about these issues. Things like the importance of client confidentiality, things that we consider that are the very hallmark of what an attorney-client relationship is based upon. But I believe this is probably one of the biggest challenges that the legal profession has. And I fear that, I don't know if there are any Uber people out here, but the Uber example is one that I use often when I speak to bar regulators who say, absolutely not, we're not going to consider any of this. I can give you the South Florida example, because of course Uber came out, it did not ask permission, it was in violation of all kinds of regulations, and by the time the regulators got involved 6 months after they arrived and said, oh, wait a minute, you don't have this, you don't have insurance, blah, 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 blah. What happened? They initially said, no more Uber Lyft, and there was a public outcry. Why? Because they were serving a function that was needed, and the consumers insisted that the regulators back off and allow it to continue. So much of my discussion with legal regulators is to say, if 80% of the people in our country are not able to access lawyers, there are people out there who will figure out a way to provide this service. And by the time you get your act together to, after the fact, try and regulate them, you're going to have a similar situation where it will be the consumers who will say, I'm sorry, that's unacceptable to us. This is a service we need, we want. So I am happy to work with anybody in the room who'd like to work through this issue, but clearly it is the biggest challenge that we face. As you know, many of our state bars are finding that some of the more innovative legal providers, Avo, Rocket Lawyer, etc., violate existing regulation. And so the big challenge for the profession is, are we going to reevaluate how those regulations operate, or are we going to wait until we no longer have a choice because we're providing a service is being provided that the consumer wants, and they're not going to want to hear from the state bar that, sorry, that violates our rules.
So as of right now, there is no ABA position that's overarching as to definitions and scope.
There is no overriding definition of what the practice of law is. There is a list of criteria that we created to help define the legal relationship. And that's what we have given to regulators and say, if you include these things, everything else should be fair game.
Gotcha. Thank you.
Hey, Adam Long from 1-400. It's great to hear this kind of talk from the president of the ABA. Following up on your comments about Uber, I want to ask more about the experience in Texas. I think it's great that one time, in the face of an overwhelming emergency, the Texas Supreme Court made a temporary, narrow exception to their outdated and 15th century guild protecting regulations.
How does he really feel?
Well, Roland always yells at me to ask questions, not make speeches, so I'm trying to.
Okay.
So, but isn't the lesson, I mean, did they horribly mess anything up, these Louisiana and Oklahoma and Illinois attorneys, or isn't the lesson of this that the whole thing is ridiculous and that we should expand that to all kinds of situations where 80% of the public can't get help? I'll sit down and let you.
Okay, I don't think the challenge of 80% of our consumers not having access to legal services is caused by the fact that we have bars that require separate licensing in every state. There's a whole lot of other issues that are created by that. But again, we're talking about a transformational period. So for those of you who don't know, we do have state requirements for licensure that differ from state to state. Over the last 5 years, 30 states have agreed to use the same bar exam, uniform bar exam with minor tweaks. Now, this sounded like a really good idea. I actually am a strong proponent of it, but there are implications for that. So currently, those 30 states using the same exam have 30 different passing scores. There's never been a validity test to show that the 145 that's required in California creates better lawyers than the 132 that's required in South Dakota. I'm sure the people in California would like to say, well, we require better lawyers, but there's never been a validity test that reflects that fact. My point is not to challenge the underpinning of legal education or licensing so much as to say that this is a moving target, but one that is if you have the same test, it's really tough to say that you can practice in South Dakota but not North Dakota unless you take that same test again. So my point is, this is a rapidly changing area of the law. Bar regulators are still very possessive about suggesting that you have to go through their rigmarole in their state in order to be licensed. But I would suggest to you that there already are barriers breaking down between states as a result of the decision between 30 states agreeing to use the same exam. But the issue of 80% of consumers not having access is an issue of lawyers charging too much and not having enough low-pay lawyers who are prepared to work for consumers for less money. And whether they're from Texas or Louisiana, if they're still charging $500 an hour for their services, you're not going to solve that problem. Oh, sorry.
Oh, hi, Karen Suber from Attune Capital Management. Thank you so much, Hillary. The Continue to Be Bold message is amazingly welcome, so thank you again. My question is about the business model of law. We've talked about technology and how it will really change how we practice, and even the introduction of substitute legal providers. So given that a legal education at Harvard or Stanford could cost as much as, all in with budget, $270K, and what happens to law firm models and how we have come to be as a legal profession charging excessive rates?
Well, I'll refer to Richard Susskind, who I'm sure you all know is the author of Tomorrow's Lawyers, who suggests that the next 20 years in the legal profession are going to be more transformative than the last 200. One of the reasons that you face so many barriers in trying to incorporate technology into legal practice is because lawyers are fearful for just the reason you articulated. Lawyers believe that technology will continue to make them obsolete and unnecessary. That's a very discomforting concept for someone who has spent $200,000 to get a legal education. And obviously, the answer is not that there are fewer legal needs. We all know there are more legal needs than ever. But we can't all work at big law charging $800 an hour. The market for those services will remain, but it's going to be more narrow than ever as more and more of those legal services are taken in-house. And in-house lawyers are not at all concerned about the fact that technology is going to make many of the in-house lawyers obsolete. So you're absolutely right. One of the reasons that I have this commission on the future of legal ed is exactly that, to focus on, number one, what are the future skills that lawyers are going to need? Because training lawyers like we did in 1950 is not going to be a particularly effective way for lawyers who have to provide legal services in 2050. So we have one aspect of that effort is future skills. Should we be teaching AI to every incoming law student? Should we be teaching project management as a required course? Those kind of things are not happening today. I mean, there are innovative law schools who are making that effort, but it's very much around the edges. So this Commission on the Future of Legal Ed is looking at that future skills. They're also looking at the whole licensing issue. Should we still assume that every graduating lawyer is going to be a general practitioner? I mean, when I took my test, my bar in Florida, some years ago there were 10 topics on the exam. There are now 27. So everybody who wants to go to law school to become a family practitioner is now told they need to know about IP and criminal procedure. Does that make sense? Maybe we should follow the medical school model, where everybody has to take a basic bar after the first year, and then take a certification only in a specific specialty area that they plan on practicing in. We don't ask our neurosurgeons to take a test on pediatrics, but that's the way we license our lawyers. Everybody's still assumed to be a general practitioner. And then the third issue is access to justice. Why aren't we using our law schools to try and bridge that gap? And one idea that people constantly mention is the concept of making law school 2 years of substance and a 1 or 2 year mandatory internship where you would still be connected with the law school, but you would be working with low-income people, providing free legal services, and actually learning how to solve client problems. I know as someone who hires a lot of lawyers, there's no question in my mind that I would rather hire someone who's had 2 years of substantive classes and 2 years solving legal problems for low-income people than hiring somebody at the top of their class who's had 3 years of substantive courses. Because the former person has had that hands-on skill set. And that's one alternative way to both lower law school debt and try and bridge the justice gap. So lots of exciting ideas out there, but obviously a lot of stakeholders that you have to get under the tent to join in on following one model so that we can get something passed like that.
Thank you.
Thank you. Hillary, thank you for being here, and thank you for challenging this crowd. If you could even do it more directly and more loudly, Silicon Valley loves a challenge, so thank you for that. Unstuck, getting unstuck, stuck in silos. A few years ago, the ABA modified Rule 1.1 in its comments to talk about adding technology competency to legal competency. Curious if that's help us get unstuck, help us break down silos. If so, some examples. If not, why don't you think so?
I guess I would say, has it helped? Yes, there are multiple states that have now incorporated technology requirements in their CLE, so that for me to recertify every 3 years, I have to not only say that I've taken continuing legal ed courses, but I now have to say that I've taken a technology course. And this is a small step, but it is a recognition that lawyers, based on the current training, are woefully unprepared to try and figure out how to adopt technology. So is it a start? Yes. Is there more we could do? Absolutely. And that's why we're taking it from the perspective of legal education. Why can't we require that legal education courses, anybody coming out of 3 years of law school, has had the opportunity to take certain classes or even require them to take certain tech classes? I think that's a more likely alternative. One of the other things we're looking at is to have an innovation index. If you are an incoming law student, you really have no ability to determine whether or not one law school has more innovation classes than another. We were talking last night about some, I know Dan's trying to do that right now. There should be a way for incoming law students who are smart enough to figure out that they want something other than the old school model to find out which schools will offer it.
Thank you.
Hi, David Wang, Wilson Sonsini. Thank you for being here today. My question is also about the business model of law firms. So the billable hour, right? The habit of lawyers charging based on their input rather than their output. I think many people have found that that's kind of one of the fundamental impediments to the adoption of legal technology because, you know, it does not incentivize efficiency. Correct. In fact, it disincentivizes efficiency. So I'm wondering, you know, the ABA, as you mentioned, is taking an initiative to update billable codes for billing hours, but can we see some leadership from the ABA about what to do about the billable hour model itself and how the profession can kind of come to alignment with other businesses on charging based on
Well,
output?
I think we're coming to alignment, not because the ABA is demanding it, but because our clients are demanding it. I have 2 or 3 major clients that have come out publicly to say that they are going to 100% fixed fees. And this is something that I think is spreading like wildfire in the business community. So one of the reasons that we're changing the codes is to be responsive to our client demands, because if you're insisting on fixed fees, those old codes will not help you get there. But I absolutely agree that the biggest single incentive for lawyers to adopt technology is the idea that our clients are demanding that we be more efficient. And once you're working on a fixed fee arrangement, trust me, all that technology is suddenly going to be very appealing because you're being incentivized to be efficient rather than the other way around. So that's what's going to change the model.
Thank you.
Well, thank you so. Oh, we have one more. We have time for one more.
Wanted to know if the ABA is going to help bridge the gap between smart contracts and the way the world works today with attorneys. Is there an effort to have perhaps an ABA model opinion letter? Because most transactions of substance require an opinion, and if there's smart contracts involved, I'm just visualizing the opinion committee having a challenge with that.
We actually do have a number of those types of forms available to our members. I know business law, for example, has a number of forms that they provide to their members. One of the things we're going to be doing next year through this blueprint model, which is something that really started with a focus on small and solo lawyers, but providing through the web access to forms, outlines for particular types of DEPs, all those types of things. We have this enormous amount of substantive information, but it's not particularly easy to find for a member. So this blueprint effort is our way to make it easily findable, and within the next year that will be available to every ABA member. So if you say, I'm going to do a deposition of a malpractice defendant, you type that in and you will get the form for the basic things that you need to be asking about. Similarly for a contract. Well, thanks again for the opportunity to chat with you.